the conversation through class. So that's why we're recording it. So, all right. Welcome, everybody. Thank you for coming out on this rainy day. Did y'all hear that thunder last night? It never stopped. Thunder in February, that's really kind of odd. But my name is Dana Sparks. I am the director of the Georgia Real Estate Academy, which is the entity offering this course for CE credit. So welcome, everybody. We do welcome agents from all brokerages. We have a huge philosophy in the importance of training and education, regardless of which broker holds your license. The better trained and informed we are, the better it is for you as an independent contractor, the better it is for our clients and our customers and our public, and the better it is for our industry as a whole. I am also the managing broker of Maximum One Realty and the qualifying broker of Maximum One Greater Atlanta REALTORS. So on a selfish note, I would rather have an agent whose license I hold doing a co-op deal with somebody else that I know has been in one of my classes and has been exposed to the information. So welcome, welcome everybody. Okay, this is a fun class. We have a lot of information. This is called 2019 Contracts Review, GAR versus RE. Take one of each, please. You just made it. Contracts Review. So what we are going to talk about in today's class, a couple of things. One is the 8 essential elements of an enforceable contract for real estate, where you can find those essential elements in both the GAR forms and the RE forms. The second thing we're going to talk about is this is a true direct comparison between GAR and RE. And I have a feeling that's most of the reason why you guys are here, right? So welcome everybody. I do welcome questions and comments. Please know if I cut you off, take one of each of those handouts, please. If I cut you off, please know I am not intentionally being rude, but in the interest of time, we have a lot to cover. I am not going to dim the lights. You guys, again, you have 3 packets. Let me tell you what's in your packet. I need to change the pictures, but on one it says 2019 Contracts Review, GAR versus RE, handout 1 of 3. On the second one, I have 2019 Contracts, GAR versus RE, handout 2 of 3 GAR contract forms. On the third one, I have 2019 Contracts Review, GAR versus RE, handout 3 of 3 RE contract forms. Okay? So in the first one, it's just my outline, and it is a table of all of the differences and where you can find them in each of the form. These are sample GAR forms, so you can see actually live and in person where it is on the form. And the third one are sample RE forms, so you can see exactly what it is we are talking about. So I have some of these notes outlined. Some of them I didn't outline because in the table I referenced the specific paragraph. Okay? So it's a lot of flipping and turning. All right. Again, we will take a break. In the meantime, if you do have to use the restroom, we've got 2 restrooms, one in the workroom and one there. Please feel free to get up and use the restroom as you need to. And I'm not going to dim the lights because the slides are basically the table when we get there. So you guys can see everything, and plus you guys are going to want to write maybe a bunch of notes. All right, here we go. Essential element for a real estate contract. So the first essential element, right now the first part when we talk about the essential elements, I'm just in this, well, I'll flip and turn, but I'm starting off in the skinny little handout. First, it must be in writing. To be enforceable, real estate contracts must be in writing and contain all the essential elements to be valid. Short-term leases are often the exception. Well, it pretty much makes sense it has to be in writing, right? Until you think about how you practice. And a lot of times, what happens is a buyer's agent, a selling agent, will write an offer to the listing agent, present it to the listing agent will present it to the seller, and then what happens? You guys end up kind of talking about things on the phone or by email till you come up with sort of a final deal and then put it all in writing. That's all good and well, except for the fact that it is not binding upon the parties unless it's in writing. And do we know that the public sometimes changes their mind? Never, never. Sometimes they change their mind for whatever reason. Sometimes they'll get another offer in the interim time that you guys are emailing back and forth. So you guys, you've got to do contracts in writing. It is not enforceable if it's not in writing. Also, this is spelled out in your contract forms where it talks about the notices section. So in the GAR contract, y'all see how we're going to flip and turn. Handout 2 is GAR, handout 3. It is located in the purchase and sale agreement. In paragraph C, this little symbol is for paragraph. Paragraph C, number 1, C1. And this is talking about notices. Well, in general, the contracts have to be in writing, especially when you're sending a notice. So what would a notice be? What would a notice to a contract be? Let's say you're already binding, and now you have to send a notice. Right, a notice from the holder. If the holder never received the earnest money, that would be a notice. What would be a notice more between the parties? What's a notice y'all do all the time? Well, not all the time, hopefully. No, we're already binding. An amendment, but what else? Notice of termination, right? If you're going to terminate, so forth and so on. You guys, anytime you are basically, a better way to think about it is anytime you are communicating with respect to the contract. Now, I don't mean things like scheduling, inspections. I am on the GAR contract, paragraph C1. It's on page 4 of the GAR packet. A notice must be in writing. And so it says in writing under that paragraph, all notices given hereunder shall be in writing, legible, and signed by the party giving notice. Right? So they have that in there. So why does GAR and the RE forms that's written under the standard terms section, paragraph 11? Why does GAR and RE forms, why do they have that verbiage in the contract? Exactly, because of what we're talking about. In order for it to be enforceable upon the parties, it must be in writing. So GAR is putting a lot of elements, and the RE Forms Committee, they have a lot of elements pre-printed just to remind everybody, because not everybody has taken this class, and not all of our public people know contracts law. Neither do all of us know contracts law. But GAR puts it in here, number 1, because it has to be in writing to be enforceable. Same thing with amendments. In that same thing, under paragraph purchase and sale, paragraph C4E, it's on page 6 of the GAR handout, the second handout. Look at what it says. This agreement constitutes the sole and entire agreement between all of the parties, supersedes any prior written and verbal agreements, and shall be binding upon the parties and their successors, heirs, and permitted assigns. No representation, promise of inducement included in this agreement shall be binding upon the parties hereto. Now look what I have underlined. This agreement may not be amended or waived except upon what? The written agreement between the buyer and the seller. Again, it's one of the essential elements of an enforceable contract for real estate is it must be in writing. All right. The next essential element, there's more places. Obviously, you guys know. Also, license law says that what must you do if you receive an offer? What does license law say that you as an agent must do if you receive an offer? Present. You must present all offers. Guess what the other part of that license law is? You must present what? All written offers. If you receive a verbal offer, you are not beholden by license law to present it. Just written. All right. Next essential element of an enforceable contract is signatures. The contract must be signed by all parties. In the case of corporations or partnerships, an authorized person may sign on behalf of the entity. So let's talk about that second half for a minute. If you are working with a corporation, or for another example, an estate, who may sign a contract to do business on behalf of that corporation or that estate? Whose signature do you need? Nope, not power of attorney. Power of attorney, well, I'll get back to, well, let me talk about power of attorney. Power of attorney means I appoint you to act as my principal with respect to this. But even in that situation, you guys are bringing up another thing. So even in a power of attorney situation too. But what about if you're dealing with an LLC? If it's an LLC that's buying the property, or the person that owns the property on title has passed away and somebody wants to sell it, the heirs want to sell it. Who can sign the purchase and sale agreements, amendments, closing documents, so forth and so on? Okay, so let's talk about an estate first. Who? Executor, executrix, or administrator. What about for an LLC? An authorized agent. Okay, so you guys know, and for POA, the person that was appointed power of attorney for the principal. Just so y'all know, as an affiliated licensee, you guys do not, I suggest, do not take power of attorney for your clients. You become the principal in that transaction, and I do not believe your E&O insurance covers you if there's an issue with that transaction. Get them to give it to someone else. Okay, so we've got a POA, we've got executor, executrix, or appointed administrator to an estate, or an authorized agent of that LLC or whatever corporation that can sign to engage that LLC in business on behalf of that business, okay? Now here's the key. How do you know? Right? Do y'all think about this? Don't say, well, I don't know. No, not necessarily. Well, no, because the question was the Secretary of State. If you look up the Georgia Secretary of State, you can find the registered agent of that corporation. That registered agent may not have signing authority to engage that corporation in business. So how do you know? Yeah, you guys, I'm trying to get you to think. Y'all need to get some documentation from these people before they sign a contract. If you have an LLC that's buying or selling property and you're dealing with the person and they sign, you need to make sure that they have the signing authority to engage that LLC in business. And they have to sign it properly. They have to sign it they can't just sign their name. There's a specific way they need to sign it. So when you guys are doing business and you're dealing with one of those entities, power of attorney, estate, LLC, I can't think of any other examples, y'all need to ask for some sort of documentation that gives that person the authority to sign the contract on that behalf. Okay? Very important. In the GAR it's also talked about in the notice section of the GAR Contract Purchase and Sale, in the notice section of the RE Standard Terms, where it talks about, we just kind of read that part. It must be in writing and signed by the parties, legible, right? We talked about legible. Now, I want to talk to you a little bit more about this. Look at your GAR Purchase and Sale Agreement, paragraph C4I. So we're still right there. It's on page 6 of GAR. And in the RE Forms Contract, it's in the Standard Terms, paragraph 12.9.10, which is on page 15 of the RE Form packet and page 6 of the GAR Form packet. This is a lot of work. Y'all didn't realize you were going to have to do so much work in this class, did you? All right. So let's look at what it says in the GAR, where it says no authority to bind. No broker or affiliated licensee of the broker by virtue of this status shall have any authority to bind any party hereto to a contract, provisions herein, amendments hereto, or termination hereof. In the RE Forms paragraph 12.9.10, party. Each person named in the contract as buyer or seller, and shall not include any broker or other third party named in the contract. What does that mean? What does that mean for you as an agent? What does that mean with respect to your signature on a purchase and sale agreement? It doesn't bind anything, right? So in order for a contract, an amendment, anything to be binding upon the parties, it must include the signatures of whom? The parties, the buyer and the seller. And does it need your signature? No, it doesn't. That's a whole other discussion about what your signature indicates. That's we talk about in the contracts classes. But look at what it says also. Party does not include broker or other third party named in a contract. In every contract, who is named another third party in our purchase and sale agreements? Who else is named in the purchase and sale? Who else is named in the purchase and sale agreement? Attorney, right? And sometimes the lenders, but definitely you name a closing attorney. So first of all, is there anywhere in the purchase and sale agreements in and of themselves that you see a closing attorney, a place for the closing attorney to sign the contract? No. May a closing attorney's signature or your signature bind the party to terms? No. May an email between you and another agent bind the party to terms? No. So when you guys are negotiating back and forth and you're negotiating either the terms of the purchase and sale agreement or negotiating through repairs on an amendment to address concerns, yeah, my seller will do that. Yeah, my buyer will do that. And then you send them the actual amendment to sign and they don't sign it, can you fall back on, well, you said they would do it? No, it doesn't hold water. Okay? All right. And also on the signature page, of course, are the parties' signatures. All right, next essential element is legally competent parties. A party to a contract should be of legal age. What's legal age here in Georgia? 18. Legal age when entering into a contract. A minor entering into a contract has the choice of either withdrawing or enforcing the contract. Now also here in Georgia, a minor may buy property, but they may not sell property. So they would have to have some sort of, where it says here a minor, so that's a separate thing. And then where it says a party, a minor entering into a contract has the choice of either withdrawing or enforcing. I believe we would have to get the court's intervention in that to give them the authority to do that. But without that, a minor may buy property but may not sell property.
What's the age for the minor?
What's the age? No, what's the age? What's the age here in Georgia? 18.
Minor?
Below 18 is a minor.
So any child that's younger than 18 can buy property?
Yeah, if they've got money, I guess. But they can't sell. Can't sell. Well, you have a lot of minor children that inherit a lot of money, or it might be a parent, a grandparent, an aunt, an uncle, a friend that would make investments on behalf of that child. A lot of times it's typically handled with trusts and so forth and so on. But yeah, that would be nice. It'd be nice to have those kind of relatives, right? All right. A party is incompetent if they are declared insane by a court, not by a broker. Just kidding. Just kidding. Those who have entered into contracts while temporarily mentally incompetent due to drugs or alcohol may also be considered incompetent. Again, this is just something, hopefully that's not something that you deal with on a regular basis. The one time where we have, hopefully not at all, but the one time where we have seen it, where it actually has been an issue, is we had a situation where the person on title was a woman who at this point in time did have Alzheimer's disease, and I don't remember if she was in a nursing home or not. So her adult child had the power of attorney and was signing the contracts on her behalf as her power of attorney to sell the house. I don't know what happened. I think I know what happened, but I don't know exactly what happened, but we got to closing. The closing attorney halted the closing and said, before we proceed, I need to make sure that we have competent party. And what the closing attorney, what had to get investigated the question that came up was at the time of the woman on title signing the power of attorney, was she suffering from Alzheimer's at a level where she was not deemed competent, or was she competent at the time she gave the power of attorney to the one of the 3 adult children? So I have a feeling what happened was some of the other children called the closing attorney and probably, follow the money, right? So I have a feeling that's why it happened, because that's not a normal course of events. So basically the closing got halted, and they had to get an affidavit from the closing attorney that did the power of attorney, and from this woman's doctor at the time, that as of the date the power of attorney was given from mama to one of the kids, she was compos mentis at the time. So that's really the only time where it was just an interesting twist on that we've seen it come up. All right. Mutual agreement, meeting of the minds. Essential element requiring offer and acceptance. Where in your contracts do you know you have a meeting of the minds? Binding agreement, right? So, what is a binding agreement? Oops, I'll go to the next. I'll click it in a second. Well, I'll go ahead and do it now. What is a binding agreement?
Seller accepting the buyer's offers and all the terms involved.
It's when the last agent tells the other agent that it's okay.
So if we have a purchase and sale agreement, and we have, okay, let me do it by example. I'm the selling agent. Hope you're going to be my listing agent. Okay? I write an offer on behalf of my seller. I present it to the listing agent. Listing agent presents it to the seller. Listing agent writes a counter offer back to me. I write a counter offer back to the listing agent. Seller signs it. Do we have a binding contract?
No.
Do we have a contract with both signatures? Yes, we have a contract with both signatures. Hello. Is it binding upon the parties? No, why not? Binding agreement is notice of acceptance. Do I know, do the buyers know, or the selling agent, do I know if I'm going to get a counter offer or an accepted contract? No, not at this point in time. As soon as I receive it, well, as soon as she sends it, then the terms are binding upon the parties. Okay? Now let's say we went one more round and seller sent a counter offer back to me, back to the buyers. I've signed it, but I haven't sent it back. Now the seller gets another offer for $10,000 more. Is the seller in a position to accept that offer?
Yes.
Okay, you listing agents pay really, really close attention. So first of all, my question is, let me back up a little bit. How many houses may a buyer buy simultaneously? As many as they want, right? Those are the buyers y'all want. Hello. As many as they have money for, or you can protect them with a due diligence buyer's right to terminate, right? Buyer can go under contract for multiple properties simultaneously. How many buyers may a seller sell to simultaneously? One. Okay, let's go back. If they sell to more than one, we have issues, right? The house can't be split in two. So let's go back to this example. Hope, as the listing agent, has sent me a counter offer back. She now gets another offer that she wants to accept, that the sellers want to accept. Y'all said she's in a position to sign it. And let's say it's perfect as is. What happens if the seller signs that offer, sends it back to them, and then what if my buyers sign the counter offer and send it back? What's happened? The seller is in a world of hurt, right? The seller has just now legally, we have two binding contracts, and the seller has just sold the house to two people. It is going to have to negotiate with one of them to terminate. right? It's probably going to cost somebody some money. You listing agents, let's say now, same situation, you get another offer that you want to accept, but you have an outstanding counteroffer to buyer number one. What should you do? You need to, well, you're not going to terminate because we're not binding yet. You're going to withdraw the last offer or counteroffer. If you withdraw this offer, so I've signed it, my people have signed it, but I haven't sent it back yet. We don't have a binding contract. We don't have a meeting of the minds. Because yes, on paper we have two-party signatures, but the seller has no idea if they're going to get another counter back or a signed contract. Does that make sense? But the seller, you guys need, the listing agents, y'all need to withdraw this last open counter before you accept it. Then you buyer's agents, when you get something signed, if you're the last party signing it and you sign it, y'all need to hurry up and send it back. Because it's really difficult to explain to these buyers when they signed a contract and they're sharing this house on Facebook and social media with all of their friends, and then, oops, guess what? You get this withdrawal, right?
Because it's just a notice of withdrawal, so it doesn't have to be signed or anything by the buyer. She just has to send it to them.
So I talk about this a little bit later, but since you're asking, let's talk about it now. Notice, how many party signatures do you need for a notice? One. You only need one party's signature. So anytime you see the term notice in the purchase and sale agreements or on any additional documents, exhibits, amendments, it only needs one party's signature. Okay? Now agreement, so notice, I want y'all to think of back how we learned in elementary school, the beginning of the Revolutionary War. How did we learn about, what did we all learn in school about the Revolutionary War? Paul Revere, one man on one horse riding through Boston, nailing notices. The British are coming, right? One person giving notice that the British are coming. We're about to engage in Revolutionary War. When you see notice, one signature. Think of Paul Revere, one man and one horse. Okay? Now what's this?
Oh, a handshake, yeah.
What is this?
Two people.
Nothing.
What does a handshake indicate?
Agreement between two people.
Two
parties.
agreement, right? When you're shaking hands, what does that indicate? Agreement. How many hands? Two. Whenever you need agreement, how many signatures do you need? Two. All right. Very good. You'll never forget it now. One of each. We'll talk about that later. But he can sit here.
I got this one and two.
And here's three. Thanks. All right. Now, also, back to the essential element of mutual agreement, meeting of the minds, closing date.
And I have a quick question.
Yes.
And this is real weird, but if you have everything you need and you're in a situation where somebody's about to withdraw, you're trying to get under contract, what matters more? The time that you write that everybody's under agreement, or like an email stamp?
Okay, so let's talk about this. I really talk about this more in the contracts class, but it is really important, so let's talk about this. So in your GAR handout, in the purchase and sale agreement, it's under the notices section, where it's on, okay, so in the GAR handout, which is handout number 2, it's under the notices section, which is paragraph C1, and it's all of them. So we're going to flip between pages 4 and 5. So basically we know it must be in writing, legible, signed by the party. I'm going to skip all the rest of that. Basically, it has, when we talk about electronic notice, that needs to be by fax or email. So electronic notice suffices as notice. When you send a text, how do y'all send a text? What do you use to send a text? Is this in writing?
Yes.
No. Right now, especially here in Georgia, text communication is not considered in writing. And if y'all get text messages and you copy and paste them onto an email or another document, it does not serve as being in writing. Text notification does not satisfy in writing. All right. So, but we can do email. It does say email. Okay? Now, turn to,
Where is this in the
That is on, I'm just talking about GAR right now. It's in the RE forms too, but I'm just, so on the second handout, purchase and sale agreement, paragraph C1, notices. It's on page 4 of handout number 2. Okay, and it says, can be writing, legible, signed by the party giving notice, and then it says further down, notices shall only be delivered in person, by courier, I'm just talking about the electronic one, email or fax. Okay, now turn the page. So, it can be by email. Now, how do we know, what does the contract define as receipt? That was the question, right? So we're talking about this example, if the listing agent needs to send the withdrawal of notice before I send. So, delivery of notice, I'm on the next paragraph, B. A notice to a party shall be deemed to have been delivered and received. And again, I'm skipping to just the email part, number 3. In the case of delivery electronically, on the date and time, the written notice is electronically sent to an email address or fax number of the party herein. Wow. So what does that mean? What does that mean? So again, the sender, it's not an issue of when it's sent. The issue here, especially when we're down to a time crunch or a potential issue, is when it is deemed received. So what does that say? And we're just going to talk about email right now. When is it deemed received? What did that just say?
When you send it.
When the sender can prove the date and time that they sent it. So let's say Hope sends me the withdrawal of the last offer or counteroffer. Let's say I haven't even opened my mail yet. Is it still binding upon the parties? Is it received? Yes, it is deemed received, even if I have no knowledge of it, because she can prove when she sent it. Okay? Now, the time part comes into play if the seller sends a withdrawal of offer or counteroffer, and the buyer sends the notice of acceptance. In that situation, it does specifically say time, and it does say that we would have to look at the time, because it is deemed received when the sender can prove they sent it. So a lot of times, if there's an issue, if there's an earnest money dispute over a termination or so forth and so on, your brokers or the holders will come to you and say, okay, I don't care what the date is on the contract. I don't care what the date is on the TNR. I don't care what the date is on the withdrawal. I need to see the email or the certificate from sending it through electronic, through e-sign when it was sent, because when the sender can prove they sent it is when it is deemed received. That's specifically spelled out in GAR. I will tell you in the RE Forms Contract, it does say that notice occurs in writing and email notice and fax notice is accepted. The RE Forms Contract does not specifically go on to define when it is received. I don't know, I'm not a lawyer, I'm not a judge, I am a broker. I can tell you that I can articulate an argument as a broker that if the parties are binding on the RE Forms Contract and notice was sent electronically, I feel comfortable as a broker stating that I can go by the same definition in the GAR contract and apply it to the RE Forms Contract, although it's not spelled out. Because as a broker, that's all I have to go on, and I deal with those contracts on a regular basis. Could that be overturned in court? Of course, who knows? But again, I'm not a lawyer, but as a broker, I feel comfortable on using that same definition of receipt as defined in the GAR contract and apply it to the RE Forms Contract. Now, the other part of that is it says it must be sent to an email address or a fax number as indicated on this contract. So you agents, y'all need to be really careful, because through FMLS and Georgia MLS, sometimes your email addresses will auto-populate on your contracts. So sometimes your company will give you an email address, for example, Dana@MaximumOneRealty.com, but you guys are branding yourselves, or you just have a really cute, awesome other email address like Dana@thehouseholdname.com. Cute, clever. That's what I used to practice under. So y'all have to be careful when you get a contract and you're emailing a co-op agent back and forth. Verify that the email communication that you guys are using on a regular basis matches the email address on the purchase and sale agreement. If it doesn't, y'all need to get that squared away right now, because notice to just the email address y'all are using, if it's not printed on the contract, does not satisfy the terms of notice. Number one. The other thing is, y'all be really careful. A lot of times your brokerages will have a company fax number. Typically those company fax numbers are monitored when? How often? Monday through Friday, typically 9 to 5, when there's staff there to monitor them. When do y'all do business? You do it after 5 and you do it on the weekends. So the important thing about what we just read, because electronic notice can also be sent to a fax number on the purchase and sale agreement, on the contracts. If your contracts automatically populate with your company's fax number, y'all might want to consider taking that off, because that would mean that a party may send notice to that fax number and you won't receive it until Monday. But nevertheless, it has served as notice to terminate a contract or withdraw an offer or whatever. So just a couple of things. Did that answer? That was my long-winded answer.
Yeah, I was wondering about the differences between the two, and you beat me to it, so perfect.
All right. Now, closing date. In your purchase and sale agreements, GAR and RE, it says this deal to close on, fill in the blank. Do you see the word before? Why on earth are you guys adding it back in? We see so many purchase and sale agreements where it says closing to be on, and everybody writes in on or before such and such date. Y'all stop doing that. They took it out for a reason. Did it used to be in GAR? Who's been practicing for a while? Yeah, it used to be in GAR. GAR took it out.
Isn't it the RE form?
Nope. It just has a specific date. Closing to be on, fill in the blank, and you put in a date. Why did they take it out? It doesn't necessarily demonstrate a meeting of the minds, right? Let's say we put closing to occur on or before March 26th. Okay? And let's say the buyer gets their loan done in time, or their rate lock is going to terminate on March 16th. So they want to close, so they get their rate lock and all the paperwork is done and everything. So the buyer's agent calls a closing attorney and schedules a closing for March 16th. Then the selling agent calls the listing agent and say, guess what? We're closing on March 16th. It's all scheduled. Here it is. Here's the time. And the listing agent talks to the seller, and the seller says, I can't close March 16th. I've got all my stuff ready to close March 26th. I don't agree. And the buyer says, you already have agreed. Well, no, I didn't. Is March 16th before March 26th?
Yes.
Hello. Do we have a meeting of the minds? No. That's why the contract forms committee took it out. Y'all stop putting it back in there. Okay? Now, how can you change a closing date? How can you change anything in the contract? By amendment, right? By agreement. So that's why they took it out, because it does not necessarily demonstrate a meeting of the minds in that example. Also, don't put to be determined. If you have something to be determined, closing attorney to be determined, closing date to be determined, that can come back as not necessarily being enforceable because you don't demonstrate a meeting of the minds. Now, I will tell you guys, in practice, there's a lot of times you will put to be determined. To get binding. If you go binding with to be determined in something, y'all make sure to immediately get that determined and amend the contract to add in that date so that so you don't go through several weeks and a lot of money and then fall back on a technicality that we didn't have a meeting of the minds.
So does a closing attorney have to be named on the contract?
Mm-hmm.
In the beginning?
Yes, ma'am.
Okay.
Closing attorney is very important, too, for a lot of reasons. Title search,
money.
determining if they're, who has title to the property to convey, how far back the title search goes, if there's a cloud on title, working through cloud on title. Question.
I have a question on, sometimes I'm starting to see a lot that the listing agent says you need to close with this certain person. I don't really like that because I might not know those people and I don't want to deprive the buyer. So is that really, can they really do that? Do you have to close with that person?
So the question is, a lot of times you will see in whatever, typically on the MLS service or through conversation, it says, must close with ABC attorney. That is absolutely not enforceable. So you need to negotiate through that. That would warrant a conversation. Why is it important to close with that attorney? And it may be, is it just their favorite attorney? Or is it, we had a lot of title issues with this house. This closing attorney has done a title work. We've worked through, this was a house that was originally purchased during the foreclosure market, and all those closing attorneys went out of business, and this deed wasn't recorded and so forth and so on. There was a lot of work done to clean up the title. This closing attorney has already done it and already has everything. It's going to be better for the party. That would be, okay, well, that makes sense. Or it could be, well, there's a variety of reasons. But is that enforceable? Can you hold that? No. You would negotiate through that. Yes.
Do RE forms say who should pick out the closing?
So I'll get to that when we get to the direct comparison. Great question. Remember that question, but I will address it when we get to the head-to-head comparison, because there is a huge difference between the contracts in that. All right. Lawful objective. A contract must have legal purpose to be enforceable. Consideration. All parties to a contract must offer consideration. Consideration is something of value and may take the form of money, real estate, personal property, or services. So, what is, okay, this is going to be a pop quiz question. What is the consideration? Okay, let me give you a hint. Both the GAR contract forms and the RE contract forms, the consideration is the same, okay? What is the consideration in the purchase and sale agreements?
Is it $1?
So I have $1, I've got $10. Any other guesses? I'll tell you those are incorrect. Now do I have any other guesses? What?
A Rolex watch.
Rolex watch. No.
Repeat your question.
What is the consideration in the purchase and sale agreements? You need consideration for it to be an enforceable contract between the parties. The home? No. Earnest money? Who thinks earnest money?
No, because you don't have to have earnest.
No, correct. You do not have to have earnest money in a contract. So, do y'all want to know?
Yes. Consideration.
The consideration is mentioned in the first paragraph of both purchase and sale agreements. So let's start on this one with the RE forms. So in handout number 3, in the RE forms, page 1, the contract for purchase and sale of real property is made between, you name the buyer and you name the seller, for hereinafter described property and in consideration of the mutual promises contained herein.
The contract.
It's what they agree to do. It's the mutual promises, the services they agree, and the money they agree to exchange. In the GAR contract form, same thing, page 1.
Consideration.
The undersigned buyer, the buyer agrees to buy, and the seller agrees to sell real property, including all fixtures, improvements, landscaping, on the terms and conditions set forth in this agreement. The consideration of both contracts are the promises each make to each other.
They changed it.
They changed it from several years ago. But I'll get back to the $10 in a minute. So the consideration is, buyer says, I agree on such and such date to give you X amount of dollars to buy the property. And I'm going to give you that money in exchange for the property on that date. The seller says, I agree to sign over the deed to sell you the property with good and marketable title on that date totally unencumbered with no liens or anybody else having a potential claim to the property. That's the consideration. Who's ever done a quit claim deed between themselves and a family member or a loved one? What is it? Do y'all remember what it usually says on a consideration, for the consideration part on a quit claim deed between loved ones?
You get it all.
It usually says for love and affection, right? There's a lot of times if, like let's say you buy a house, or let's say you buy a house with a parent because the parent co-signs with you, and then at some point down the line the parent will quit claim their interest in the house just to you. It'll be a quit claim deed from you and the parent to just you, and the consideration is for love and affection. Is that something of value between the parties? Yes. Hopefully, right? Sometimes it changes between, well, anyway. So, now let's look. So the GAR contract did used to say consideration of $10, the sufficiency and receipt of which is hereby, right? So it never changes hands. Now, let's look at, we're going to have a little bit of discussion on due diligence. In the GAR contract, it's on page 1, paragraph 8AB, and in the RE Forms Contract, it is on the next page, page 2, where it talks about buyer's general right to terminate, which is the same thing as due diligence, and it says, so let's go to GAR first. It says, in consideration of the seller granting, okay, so basically due diligence period sold was subject to due diligence period of X number of days from binding agreement date. So that gets negotiated. The time frame gets negotiated. And then it says, in consideration of the seller granting the buyer the option to terminate this agreement, the buyer, number 1, has paid the seller $10 in non-refundable option money, the receipt and sufficiency of which is hereby acknowledged. In the RE Forms Contract, again, buyer's general right to terminate, which is the same thing as due diligence. You negotiate the number of time frames on the day that is blank number of days after the acceptance date. In consideration of the seller granting this buyer general right to terminate this agreement, buyer has paid the seller $10 in non-refundable option money, the receipt and sufficiency of which is hereby acknowledged. Why do they mention consideration when they're talking about due diligence? Let's back up. So first of all, $10 is the consideration. So where it says receipt and sufficiency is hereby acknowledged, it doesn't change hands. It's just to comply with consideration for a contract. Now we've already talked about the consideration of the purchase and sale agreement or the promises they make to each other. Why are we mentioning consideration when we're talking about due diligence for that period? What is due diligence? What's a due diligence period between a buyer and a seller? What does it mean? What is it? Time to do this and that for what purpose? To make sure they want it, because the buyer has the right to do what?
Inspect.
No, well, yeah. You guys, I don't know why y'all say that, but I'll get to that in a second. The buyer has the right to do what within due diligence? Terminate. Right? We're already binding, so in this situation they would have to terminate, not withdraw. You guys, a due diligence period creates a little mini option contract within the broader context of the purchase and sale. None of the other terms, now take this a little bit with a grain of salt, but none of the other terms of the purchase and sale come into play because the buyer has the option to terminate. Right? The seller grants the buyer the option for 8 days, 10 days, 12 days, 20 days, whatever they negotiate that time frame, to terminate for any or no reason. So it's a little mini option, it's a little mini agreement within the broader context of the bigger agreement. That's why separate consideration is mentioned. Okay?
I wonder why you need to use the money instead of other consideration like you do in the other paragraph, since it's not being exchanged.
Because you have to have consideration for an enforceable contract. So it's just because it's a little mini option contract. It's a little baby contract within a bigger contract. But you have to mention option. You have to mention consideration. They could have made it anything. They could have made it $2. They could have made it $20. $10 is just, I guess, legally what's a valuable consideration.
Or, I mean, why couldn't it be consideration of the mutually agree?
Probably because that's too long to spell out and they're saving space.
Yeah,
But
plus it helps us to see the difference. So that's like the right of rescission.
Yeah.
They could just say, I just changed my.
For any or no reason, the seller says, look, I give you 10 days to decide if you're going to buy this or not. Okay? So a due diligence period, a buyer's right to terminate period, I like the way RE Forms talks about it. It's a buyer's right to terminate period. It's a period of time under which the buyer has the right to terminate for any or no reason. So if a buyer's terminating under due diligence and you guys are filling out a TNR, the reason only has to be due diligence. You don't have to you don't have to tell the seller why. It doesn't matter. The seller gave them the right to terminate. So that's why I hate when you guys say inspection. Because a buyer may terminate for any reason. Does a buyer have to have an inspection? No. But during this time frame, there are a lot of things, like you said, Charles, that a buyer is going to do to decide, am I going to go through with it or am I going to terminate? What are some things a buyer does to help them with making their decision? They have an inspection. They're going to inspect the house. They're going to inspect the roof. They're going to check it out for termites and bugs. They're going to check it out for structure. They're going to check out the zoning of the property. They're going to check out to make sure the house is in the school district they want it to be in. They're going to check out their commute to work. They're going to check out to see if the people they know and love like the house. Right? They're going to check out traffic patterns. What if every morning during rush hour, I'm pulling out of my subdivision and I have to turn left across traffic and there's no light? And it takes me 30 minutes. That could be a make it or break it, especially here in Atlanta, right? You guys, as buyer's agents, let me give you, y'all want a magic website that will save you and protect you and you'll love? Google Earth. This is the time frame for the buyer to put, and you suggest to the buyer, go put this property address in Google Earth, right? And they will see the nuclear power plant 2 blocks behind that they can't see because of the cedar cypress trees, right? That's something, could that be a make it or break it issue for somebody to buy or not buy? Yeah, it could be. Or they could get a really good deal on the property, right? These are all things along with a myriad of other things. Checking for radon, checking for asbestos, checking for lead-based paint. These are all kinds of things that a buyer typically, seeing if there are sex offenders in the area, seeing if it's been a meth house.
You know, one of the things that I find now is looking at the development plans for 10 years down the road and things like that.
So all those, you guys do not do your due diligence for your buyers. This is something they need to do on their own. But these are all types of things, including an inspection, and the inspection may be from a certified inspector. You guys, our inspectors here in Georgia are not licensed. Some of them are certified, but they're not licensed. They could have a certified inspector. They could have their friend who's a handyman come over and inspect it. It doesn't matter. These are all steps that a buyer takes to make the decision if they are going to terminate or not terminate. Now, I'll get more into that when we get into some of the differences between the GAR and the RE forms. But that's why you have a separate mention of consideration in this paragraph when we are talking about due diligence, because we've got a separate little mini option contract within the broader context of the purchase and sale. Okay? All right. Now, another essential element of real property in Georgia is a property description. A contract must identify the property being sold. While street address is sufficient, the legal description should be used to clearly identify the property. How many Peachtree roads are there here in Atlanta? More than one. Therefore, how many 1, 2, 3 Peachtree roads are there in Atlanta? More than one. You guys, here in Georgia, a street address is not sufficient. Maybe in other parts of Georgia, but definitely in metro area, in the areas typically where you guys are buying and selling or helping people buy and sell, you absolutely need a full legal description, not just a street address.
And where do you get that?
There are a variety of places where you get that. You can get that from the online, the county online tax records. You can get it. There's a website called gsccca.org. Now, that is a paid website you'd have to pay for.
Are we?
or you can get, we have it, we pay for y'all. Or you can contact your favoritist closing attorney and get it from them. Realist, y'all have access to Realist through FMLS and Georgia MLS. Sometimes it will have a legal description, but it is not necessarily accurate. I would not rely on the legal description from Realist.
What was the GC?
GSCCCA.org. Georgia Superior Clerk of Courts Co-op Association.org. That's why there's 3 C's. GSCCCA.org.
So for the things that just pop up automatically, the lot, are you saying don't use those? Or-
So what's the best legal description?
The deed.
The deed. What deed? The warranty deed. So you listing agents, y'all, when you're taking a listing, make sure you get a copy of the warranty deed from the seller. Y'all need to all go home tonight, make sure you have a copy of your warranty deed for your home, right? If you're a buyer's agent and you don't have a copy of that, where do you find it? Well, you go to one of these sites. So it would be the deed to get the deed. The next best legal description would be what? If you don't have an actual copy of the warranty deed. Court records, but on the, let's look at the purchase and sale agreement. So on the purchase and sale agreement, on both of them, under legal description, it says attached here too, and that would be typically a copy of the deed. Deed book and page, and then land lot, district, section, lot, block, unit, phase, section, county, plat book and page. Of those 2 options, which is better? Which is potentially more complete? The deed book and page. Because the problem is, if you don't have all that information in the next section, if you don't have, a lot of times an agent will just fill out land, lot, and lot. They won't have the section. They won't have the rest of it. It's an incomplete legal description, right? Land lot is like a subdivision can be in the same land lot, a whole subdivision, right? Do y'all remember the old FMLS Map Books? Who's been practicing with this?
Lord.
You guys, those things were awesome. Because it had your legal description on the map book. You would find the property on the map book. You could find the land lot. You could find the lot. You could, it was kind of hard to see, but you could follow it around. You could find the section. You could find everything. They were fabulous. But now everybody relies on GPS. But anyway, between those 2, if you do not have all of the information for land lot, district, section, blah, 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 plat book and page in and of itself is not a sufficient legal description. If you don't have a copy of the warranty deed, the next best thing is to indicate the deed book and page. Now these are deed books. Where are these housed? Yeah, at the county courthouse. So when you have a deed book and page, who used to go to the courthouse to look them up? You guys that have been practicing newer, y'all are missing out. Y'all missed out on some great field trips. But what somebody can do is they can go to the county courthouse of that county, go to the clerk's office, you go and they're numbered books, right? And you find the deed book number and you pull it down and you open it up and you flip to whatever page it tells you to go to. And guess what's there? A copy of what? The warranty deed.
So if you're selling, you should attach your legal description to the listing?
Absolutely.
And you get it the same way the GSCC?
Yes, or if you're selling, you really should get it from the seller, should have a copy of their warranty
If
deed.
I'm the seller, how do I get it?
You should have it from, you should have it. That's what I'm saying, you guys all go home tonight and find your warranty
From the
deeds.
closing documents,
Yeah.
I would have it?
Yes, yes. And if you cannot find it, you can look it up, go back to the attorney that closed, or you can look it up or get with a closing attorney. All right. And the last thing is price. The purchase price or sales price must be stated. The parties may also use some reasonably ascertainable figure such as appraised value as of a specific date. You can't say appraised value in general. You have to say something as of a specific date, right? Again, because if you have something with the appraised value, well, hello, what happens to our market? It changes. So if you just say the appraised value, well, If I'm a seller, I want it when it appraised high. If I'm a buyer, I want it when it appraised low. So you need to say the appraised value. And you guys, this sounds weird if you're selling houses, but a lot of times, do I have any land sellers? Any people that deal with land? So a lot of times, we don't necessarily know what the value is of some land, and we will have to go through. So you're going to say the appraised value as, let's say we're going binding today, you would say something like the appraised value as of March 20th, 2019, or it's time to get an appraiser out there. So you would, the buyer and seller agree that whatever a third-party appraiser comes up with. So again, you're not going to leave it open-ended in general, because again, we don't demonstrate a meeting of the minds, because I'm going to want it to appraise high, I'm going to want it to appraise low. Right? It's just like the tax assessments on your house. Who lives in Cobb County?
That's an opinion.
Okay, so we didn't get a chance to vote on the Braves Stadium, and it wasn't going to hit our taxes, but what did everybody in Cobb County? We all ended up paying, go Braves,
Thank you.
right?
Thank you.
Just saying. Now, wouldn't it be nice? Is the tax value always the appraised value? No, not necessarily. Wouldn't it be nice to go to our counties that appraise or that give us a tax valuation of our house and say, if this is your valuation of our house, I'll sell it to you for that price. Do you think they would buy it? Just a thought. All right. Any questions? And this obviously is in the purchase and sale and the real estate contract. All right, any questions on the essential elements of real estate contracts in Georgia and where you can find them in the purchase and sale? All right, I'm going to have a quick discussion on the next part, legal effect of a contract. Valid, an agreement contains these essential elements. A contract agreed to by all parties and meets the standards of the contract is legally binding and enforceable. Void, an agreement is missing one of the essential elements and has no legal effect. A contract that does not meet the criteria for contract law because it may contain illegal intent and is unenforceable. A void contract is never valid from the beginning and cannot be enforced by either party. For example, typically a minor entering into a contract. It can never be enforced because it has something that is, it was never enforceable even from the beginning, or malintent, so forth and so on. Voidable means basically at the time you go under contract, let me just read it. An agreement that contains all of the essential elements of a contract, but from which, because of a defect in one or more of the elements, may be removed by the injured party. A contract which may appear legal but fails to meet some legal requirement. As a result, one or more parties can have the right to rescind the agreement within a certain period of time. The contract is valid but is also voidable or enforceable. So an example of that would be, let's say you have a seller, let's say you have a property where the seller passed away. And the heir, the person that was named in the heir, one of the children, let's say, wants to sell the house. And they sign the contract. So you go binding with them to sign the contract. They have not been through probate here in Georgia. That would be a voidable contract because they did not have the authority to engage the estate into any kind of business. So the buyer has the option of rescinding the contract saying, I'm done, bye, I'm done. Or you can wait until it gets into a status where it would be enforceable. In other words, go through probate. The probate court deems the person that signed it, yes, you are the named executor or administrator of the estate. Does that make sense? So it's not void, it's just voidable because it's not legal yet. Same thing with an LLC. If you have somebody that's a signing member of an LLC, engages to buy or sell property, but you look and you see the LLC has been dissolved, even if that person was signing, well, it's voidable, and the party that was the harmed party can say, yep, I'll wait till you get it into a state where we can enforce it, or nope, I'm rescinding the contract. Okay?
If the estate's, I think, an irrevocable trust, then you don't have to go through probate.
I'm not going to get into any of those issues right now. I'm just talking about voidable.
Okay.
All right. Validity, an agreement that once had validity but which now the validity has ceased. An enforceable contract that a court would allow and uphold, contract which meets all the requirements of the contract and offers legal remedies if not fulfilled. All right. You guys ready? We're gonna start this a little. Unenforceable contract that a court would not allow to and not uphold. A contract which appears to be valid, but it offers no legal remedies if not fulfilled. For example, Joe Smith enters into a verbal agreement for the sale of Sally Gold's property. This contract is unenforceable. All right. Dun dun dun. You guys ready? GAR versus RE. Ding ding ding. I was gonna put. Who saw Rocky? The first Rocky. So you know at the very end when it's Apollo Creed and Rocky exchanging punches and you don't know who knocked out whom, or that's what I was trying to do for this slide. But number one, I couldn't find it. Number two, I thought, I might have some copyright issues. So I just had the boxing gloves, GAR versus RE. Ding, ding, ding. We're going to go through all of this, and then we'll take a break in a little while, and then we will come back. Sound good? All right. Here we go. So let me tell you where we are in your handouts. In the little handout 1 of 3, I am on page 3, which you can sort of read it at the bottom. I have all of these slides in your handout is on this table. So the way to read the table is it has date of the form, and then I have a column for GAR, and the paragraph in GAR where you can find it. And in the RE form, what the provision is, and the paragraph in the RE form where you can find it. I'm not going to go through all the flippy like we're doing unless there's something I specifically need to point out to you. I have it here as a reference. I'm really going to talk from the slideshow. Is that okay with you guys? Again, because it's a lot. But I just want y'all to know you have it all written. You can take, obviously, additional notes. But hopefully, and when it has like, for example, it has GAR F201, that's the form number, and then the paragraph, and mostly it's going to be in the purchase and sale. Is that okay with everybody? All right. Date on the forms. So when I talk about the date on the form, what I'm talking about is the date at the bottom. So in the GAR purchase and sale, you'll see at the bottom of every form, all the GAR forms, you'll see, I just said I wasn't going to do this, but I'm going to do it anyway. So you'll see on the purchase and sale in GAR, it says F201, that's the form number, purchase and sale agreement, page 1 of 8, and then see where it says 1119. In the RE forms, very first page in the RE forms packet, very bottom, RE 100, contract for purchase and sale of residential real property, copyright what year? 2017. So GAR, this is the difference between the contracts. GAR revises their contracts every year. So you will get a new copyright date every January, and then they typically do a mid-year revision, usually about May. Last year they did a May revision and an August revision. But you will have the date on the bottom. And part of GAR's licensing agreement is once the new version is out, it's against GAR's licensing agreement to use previous versions. Okay? But in the RE form, the date is the last date that form had been revised or modified. And there is no licensing provision for the RE forms, nothing in their copyright about any of the dates, because that's all that's available. They don't redo their forms every year. Remember when GAR used to redo them every year too, right? So that's a difference between the contracts. So a 2017 RE form is perfectly acceptable to use. A 2017 GAR form is absolutely not acceptable to use due to GAR's copyright licensing agreement. All right, the fill in the blanks and the legalese. In GAR, all the fill in the blanks is on page 1, and then the legalese is throughout the rest of the contracts, of the forms, right? In the RE forms, the fill in the blank is throughout all the paragraphs. Now, another big difference that I have to talk about here between GAR and RE in the GAR purchase and sale agreement, it's 9 pages. And that has, like, the front page has all the fill in the blanks, and the rest of the pages have all the corresponding paragraphs or the legalese that respond to the promises and consequences and responsibilities that they agree to make. In the RE Forms contract, their actual purchase and sale is included in 2 forms. There's one form, RE100, that's the actual contract, and that's only 5 pages. Then there's another form called Standard Terms that is 9 pages, and that's where all the legalese is. You'll see, look at the RE Forms Purchase and Sale, the very first page, page 1. After you fill in the buyer and the seller name, and we talk about the mutual promises contained herein, in bold, in all caps, it says, this contract incorporates by reference those certain standard terms for the purchase and sale of Georgia real property published by Orthros Real Estate Enterprises, LLC, at www.reformsga.com, and in effect as of the offer date, the standard terms, which standard terms shall become a part hereof by reference thereto. Each party, by affixing his or her signature hereto, expressly agrees that he or she has read the standard terms and that it is his or her intent that the standard terms shall be incorporated into and are part of this contract. What does that mean?
It means that you're agreeing that you've read the terms.
It means that when a buyer writes their name to an offer and a seller accepts it, that when they write their name on page 5 of this little 5-page document, that they're saying, I have gone to a computer or to my phone or to my tablet, and I have gone online, and I have gone to www.gareforms.com. I have read through that 9-page document, I understand it, and I agree that that's part of the contract. Right? Let me just show you another quick example. At the very bottom of the RE Forms Purchase and Sale Agreement, it talks about earnest money. And it says, the very last sentence on page 1, it says basically in the event said payment, meaning the earnest money, is not timely remitted, the seller shall promptly be notified by the escrow agent, and the seller shall have the rights and remedies set out in this section. So that means if the buyer never remitted the earnest money, or it bounced from the bank and the holder's not in possession of it, then the seller, don't you think the seller's going to want to know what their recourse is if the buyer hadn't made good on the earnest money, right? So it says rights and remedies set out in this section. So the seller's going to say, okay, what are my rights and remedies? Turn the page. What do you see? Hello. Is that a right or a remedy for the seller? No. Where would the rights and remedies be spelled out for the seller? In the standard terms. So the standard terms is all the corresponding legalese of what the fill in the blanks are for the purchase and sale in the RE forms. I highly encourage every agent to actually, now you guys, so the public needs to go online and go to this website referenced. You guys as agents have access to the standard forms any place you access your contracts, through RDocs, through FMLS, or through Transaction Desk through Georgia MLS. I highly encourage you guys to print out the standard terms just like you're going to print out any other documents that go with your purchase and sale agreement. Attach them to the contract and reference them as an exhibit. Because a seller is going to want to know, what their rights and remedies are if the buyer, but they're not thinking about it right now. They're thinking about it when you get notice 10 days from now, 12 days from now, that there's no earnest money in the deal, right? So that's why I highly encourage you guys to go ahead and print those out, attach them to the contract, because are your buyers and sellers going to go online and read that whole form? Are your lenders going to go online and read that form? Are your closing attorneys? No. You guys really need to help yourselves out and help all the parties out by going ahead and referencing them there. All right. Forms. The GAR has a specific form for a variety of situations, right? They have a specific amendment for a ton of different specific certainties. In the RE forms, they are multi-use. For example, GAR has an amendment to change the closing and possession date. GAR is specific amendment. The RE forms, they have multi-use forms. So if for RE, you would just find an amendment, and you have an so the amendment, you can amend the purchase and sale agreement, you can amend a buyer brokerage or a listing brokerage agreement, you can amend a lease, so forth and so on. And so it has what contract you're amending, who the parties are, and then it has a space to write out what the amendment is, as opposed to a specific form for each and every situation. All right, names of the parties and signatures and initials. In the GAR contract form, the names of the parties are only on the signature page, and initials, it has a place for the buyer and the seller to initial at the very bottom of page 1 of the purchase and sale. And signatures on the signature page. So their names are on the signature page, they only sign it on the signature page, and they only initial the first page. In the RE forms, the names are on the front page. So isn't that nice? I think that's nice, having the name, especially if you're a listing agent and you're dealing with multiple offers. It's just a little, I just think it's a nice thing. But anyway, so you have the names on the purchase on the front page and the names on the signature page. Initials in the RE contract package, you have to initial every page, and the signature is just on the signature page.
And you initial every page for the initial offer, not once it's binding.
Correct. The buyer's going to initial every page. Right. All right. Deed and title. Any questions on the signatures or initials? I will tell you that Georgia is not what's called an initial state. So if you have, if it has a fill in the blank for an initial, for example, on the RE forms where it has initial on every page, or we have a lot of agents that in the GAR contract form will put a fill in the blank on every page for the parties to initial. If a party misses an initial space throughout the purchase and sale agreement, but their signature is on the signature page, it is still enforceable. So just because they miss an initial does not make it unenforceable or voidable in Georgia. All right? It's just more of a thing where you can say, yep, I saw that page. Yes, I saw that page. Yes, I saw that page. Yes, I saw that page. All right. The type of deed deed and title. The type of deed is limited warranty deed, and the title is good and marketable. That's the same in both. Who can tell me what limited warranty deed is as opposed to general warranty deed? GAR used to convey general warranty deed years ago, but now it's limited, and RE forms conveys limited. What is the difference between limited and general? Yes?
Limited is for the time that the seller has had the property. In general, goes back beyond that.
Correct. Limited warranty deed means the seller warrants the title only during the time of their possession or their ownership while they had the title. General warranty deed means they own it or they warrant the title from the beginning of time into perpetuity. Which would you want to convey as a seller? Limited. Probably limited. Which would you like to have as a buyer? General. Probably general. All right, good and marketable title. They both say the title, the seller must convey good title and it must be good and marketable. What does good and marketable mean? Free of liens? No. Insurable? No. Partly both. So not. No, but your answers are exactly what your public thinks. So how do we know what it means? Well, let's go to the contract and find out. You guys, your contracts are nothing more than a set of instructions. So in the GAR purchase and sale, it is on page 2. And it is in paragraph B1B. The very bottom, the last sentence of B1B. Good, are we all on the same page?
Is that
Okay.
B1B?
B1B, paragraph B1B, page 2 in GAR.
And what about the real?
I'll find it in a minute where it is, but the definition is the exact same. Good and marketable title, as used herein, shall mean title which a title insurance company licensed to do business in Georgia will insure, so that was partly included, obviously it has to be insurable, at its regular rates, subject only to standard exception. You guys, good and marketable has only to do with the price of the premium for the title insurance So, let me look up quickly where it is in the RE forms. So, are there different title insurance companies here that do business in Georgia? Are there different, so let's talk about car insurance. I'm going to have to look it up at the break, but the definition is the same in the RE forms. It's in the standard term somewhere. So, if you are trying to get car insurance, can you get quoted a different premium from, for example, Allstate or State Farm as opposed to Geico, Progressive? Yeah. Why do you get, let's say obviously your driving history is the same. Why do you get quoted a different rate?
Depends on where you live.
Zip code.
It depends also on the balance, the bank account of those companies. And it depends on the risk tolerance of those companies, right? So for example, you could be the same person, same driving, I mean you guys do that, right? Y'all shop around for car insurance to find out, right? So title insurance, where it says, where the contract mandates that the seller convey good and marketable title, it just means that the title insurance company must offer, the premium that they offer for the title insurance is within their limit with whatever it said, the customary, let me see, what did it say? Rates subject only to standard exceptions. So if the title insurance company, there are some title insurance companies that are willing to take a bigger risk than others. So that might be something, getting back to the closing attorney issue. You might have a closing attorney that writes title insurance for a multiple number of title insurance companies, whereas another closing attorney might only write title insurance for one company. So if you're closing with a closing attorney that writes for multiple insurance companies, if one title insurance company won't write it at standard insurable, they'll go to good and marketable, they'll go to the next one. And an example of the risk would be, for example, as we went through the foreclosure market, the same example I used earlier, there are a lot of properties that have a cloud on title because it was purchased as a foreclosure and the bank did or did not have the deeds, or the closing attorney has gone out of business and never recorded the deed, so forth and so on. There's sometimes it's not necessarily a break in the chain of title, but it's a cloud. And so the new insurance company with a new buyer, the title insurance company might say, you know what, that's fine, I'm willing to take that risk that there's not going to be a claim against the title. Another title insurance company say, no, I'm not willing to take that risk. I'll still insure the property, but you're going to have to pay a higher premium for that. So if you guys are and this is, I haven't heard of any specific cases in a long time with this, but if you're in the middle of a transaction and the closing attorney comes to you and says, we can't issue good and marketable title, it doesn't necessarily mean it's uninsurable. It just might mean there'll be a higher premium, and you would want to ask, well, how much will it be to insure it? And then that would be a decision for the parties. Does that make sense?
In other words, you can get out.
Well, in order to quote unquote get out, out, no, you can't necessarily get out. You guys, your parties can't just terminate a contract for any and no reason. Again, you need to go to the purchase and sale to talk about when they can get out or not out. But in that same paragraph, it does say the buyer has the right to examine, the first part of that paragraph says, the buyer does have the right to examine that title. If they find an issue with the title, for example, it's not good and marketable, they would have to pay a higher premium, or something else going on with the title. Nope, you're not authorized. You signed as the LLC to sell it, but you're not an authorized signer of the LLC. The buyer has to send notice to the seller. How many signatures? One. And then the seller has, if the buyer's written statement of title objections prior to closing, if the seller fails or is unable to satisfy valid title objections at or prior to closing or any unilateral extension thereof, which would prevent the seller from conveying good and marketable title, then the buyer, among its remedies, may terminate without penalty upon written notice to the seller. So in that specific instance, yes, the buyer does have termination rights, but the buyer still first, you can't just not close. If the buyer just fails to show up at closing, let's say you find out you get a call from the closing attorney and there's an issue with the title. And can the buyer just not show up to closing? If the buyer doesn't show up to closing, will the buyer get their earnest money back, or has the buyer defaulted? No, the buyer defaults. You have to go, you guys, you've got to read your contracts. It tells you what to do. In that situation, the buyer is required to first send notice, meaning you buyer's agents, you can't just email or call the listing agent, hey, we got a message from the closing attorney, there's an issue with the title, y'all need to fix it. Is that what the contract says? No, the contract says what? I just read it. You have to send notice. Notice, we know from what we read earlier, must be written, legible, and signed by one of the parties. So you have to write it out in a notice. There's a title objection in our examination per paragraph B2, seller, you need to fix it. The seller has until the last contractual date of closing to fix it. If the seller doesn't, the buyer must send notice of termination. They must send notice of termination when? Prior to closing. You can't just fail to show up to closing. If you fail to show up to closing, regardless of your reason, you have defaulted on the contract. It's all spelled out. All right. Moving on.
Also,
Yes.
finding information in the RE Forms on page 711.
Thank you. I appreciate that. So paragraph 711, where is it?
The last sentence, under 1, good and marketable title,
Thank you.
page 7.
Page 7. Okay, page 7, so we're in the standard terms. Yep, property description, paragraph 1. Good and marketable title shall mean title insurance which title and company licensed to do business in Georgia will insure at its regular rate subject only to standard exceptions. Thank you for finding that for me. All right, moving on. Earnest money deposit by holder. So when for a buyer to remit the earnest money, that's negotiated between the buyer and the seller, right, in both sets of contracts. But what's pre-printed in each contract is once the holder's responsibility. When do I have to make the deposit? In the GAR contract, I have to make the deposit in 5 banking days. In the RE forms, I have to make the deposit in 3 banking days. All right, pop quiz. Are federal holidays banking days? No. Is Sunday a banking day?
No.
Okay, here's the quizzy part. Is Saturday a banking day?
Because everything transpire on
Monday through Friday.
The answer is no. Saturday is not a banking day. Now, banks are open for consumer convenience, but it is not considered a banking day. All right. Time frame to cure. So let's say the buyer never sends it or it bounces from the bank. Either way, the holder is not in possession of those funds in their account, right? So the holder sends notice to all parties saying, You guys, in essence, your purchase and sale agreements for the holder, it's a receipt, right? If you're giving me a check for $3,000 and it's written in here and you've signed, you're my agent and I'm the broker named as holder and you sign, in essence, this is a receipt that I agree that I have the buyer's $3,000. So if I never get it, you better believe your holders, they should be sending notice saying, look, this is a bad receipt. I don't have it, right? Now there's other issues in there too. But so the holder sends the holder sends notice, I don't have the money. I either never got it or it bounced from the bank, so it's not in my account. The buyer has a time frame to cure. So in the GAR contract, the buyer has 3 banking days. In other words, the buyer has 3 banking days from the date of the notice to make good on that money. And in the RE forms, they have 3 calendar days to make good on that money. Now, what happens if you get that notice from the holder on Friday and Monday is a federal holiday? Yeah, that buyer better get up and get to the bank Saturday morning. Right now, it's not a banking day. This is a calendar day. But then by the time Tuesday hits, right? So that's just a big difference between the contracts. Closing costs. GAR, the amount that the seller is contributing to the buyer's closing costs is spelled out. You have to put in a specific dollar amount. In the RE forms, the fill in the blank for the seller's contribution to closing costs is a percentage or a dollar amount. So you can put in the percent of the sale price. So you can put in, when you're writing an offer on GAR, seller to contribute, for example, 3% of the purchase price at closing costs. That way, when you're negotiating counter offers, that percentage, if you're negotiating and you're countering the sale price, that percentage of seller's contribution to closing costs rolls with whatever you're changing. Right? If you put in a specific dollar amount, that might be something to pay attention to when you are countering. What can the buyer use the closing costs for? That's a big difference in the contracts. In the GAR, well, both you have to have, the lender has to, it's going to be used for lender items, right? Closing costs, prepaids, escrows. The GAR contract says it's up to the mortgage lender and any unspent sums go back to the seller. So the lender can only use them for specific lender-related items. And if there's money left over, let's say the seller agreed to contribute $5,000 to the buyer's closing costs, the lender's funds, the lender can only use $4,500 of that. The other $500 gets credited back to the seller at closing. In the RE forms, whatever the seller agreed to contribute to the buyer's closing costs, the buyer gets the full use of that money. So the lender is first going to use it for any lender-related items, prepaids, closing costs, escrow, so forth and so on. Then you can use it for anything else in the contract. And what the verbiage is any purpose whatsoever, merely at the discretion of the buyer. That means the buyer can use it, they can pay HOA dues, they can pay home warranty, they can pay hazard insurance, they can use it for anything they need to use it for as a credit on the closing statement.
So, Dana, what
But they can't get cash.
No.
Say my company is using the RE forms and ABC company is using the GAR forms, and their broker insists that they use the GAR forms, and you present an offer, and they may send the offer back as accepted on the GAR form.
Okay, so a couple of issues there. The question is, if I'm writing an offer on the RE forms, and my co-op agent says, my broker only accepts GAR forms. Now I'm going to,
It happens all the time.
so I'm going to be politically correct, especially since I'm being recorded. And I'm going to say that that agent totally misunderstood their broker.
Yes. Yes.
Because, so let's say that you told me that you only accept GAR forms. Really? Oh my gosh. You mean you can't write new construction? You can't help buyers buy new construction if it's not on a GAR? What are they going to say? Well, what? That's different. Well, how is that different?
Resales, really.
So-
Something that's listed.
So that means you can't help your buyers buy a HUD property? That is a HUD contract? Is that authored by the Georgia Association of Realtors? No. Who authors the HUD contracts? Department of Housing and Urban Development. You mean, oh my gosh, you're so limited. Well, you can only do residential resale. You can't help buyers with new construction. Well, and the agent's going to say exactly that. Well, no, I can write new construction. Well, not all new construction's on GAR. Some of it's on an Atlanta builder's contract. Well, no. Well, that's not what I mean. Oh, really? You guys, that's why I'm saying they misheard their broker. They can't, and what does license law say about presenting offers? Must present all written offers. Doesn't matter on what form it's on. What if a buyer has an attorney write up an offer for them?
That's a
Right? Yeah. Do they have to present it? Yeah, absolutely. Now, so a couple of issues that you said. One is if you hear a co-op agent saying, my broker says we only accept GAR forms, again, I'm going to be polite and say they misheard their broker. Because I would not imagine that would be true. Because that means new construction contracts written on an Atlanta Builder Association form, contract written by an attorney, Fannie Mae, Freddie Mac contracts, HUD contracts. That means they wouldn't accept any of those. That severely limits the scope of business that agent can practice being with that broker. Now, that being said, a party can always counteroffer on another form. So if a buyer presents an offer on an RE form and you receive a counteroffer that's completely rewritten on a GAR purchase and sale agreement, then as the buyer's agent, what must you do to any offer or counteroffer?
Rewrite it.
No. What did you just say before? What must a listing agent do? Present. No. Present. You guys, you buyers, that comes for you too. If you get a counteroffer, you must present the counteroffer. So if you get a counteroffer rewritten on a different purchase and sale package, you must present that counteroffer to your buyer. That's why you guys are in this class. Seriously. I'm so excited for you guys to be here so you know some of the differences. So you go through some of these differences. And it depends on your client. It depends on the situation. Your client might say, wow, these terms are really better for me. These terms are more favorable for me. No, or I don't care. I accept these terms. It's not a big deal to me. I'm neutral with respect. That's why you guys are here, so you know the differences between the two. So if your buyer likes the counteroffer on another forms package, can your buyer sign it? Yes. If your buyer doesn't like that, then what would you do? Now you would counter on another thing, right? So it doesn't matter. It doesn't matter. It's up to whom? It's up to the buyers and the sellers. You guys, if you advise a buyer or seller in that situation what contract form to use, guess what you have just engaged yourself in? The unauthorized practice of law. You cannot advise a buyer or a seller what forms to use. Only an attorney can do that. That's why you guys are here learning about the differences. So you can go through the differences and help a buyer figure out what the terms are. Is it important to him or her, or is it not? And then proceed. But you cannot advise a buyer or seller what forms to use. That is the unauthorized practice of law. Did that answer? So what do? So in practice, that's what you do. So you have that discussion with them. You sort of say, really? Well, gosh, anytime you get a buyer that wants to write new construction, refer them to me. I'll send you a referral fee because my company allows me to write on Atlanta Builder. Oh, well, anytime you have a buyer that wants to buy a HUD property, refer them to me because my company allows contracts on HUD forms, and I'll pay you a referral fee. And they're going to say, what are you talking about? Because that's what I'm saying. They misheard their broker. But if you have that discussion with them, and they must present. If it gets more contentious after that, then you get with your broker. You have your broker talk to their broker, and I guarantee it will get worked out. Okay? All right. Moving along. Contingencies included. How are we doing on time? 11, 12. Okay. All right. We're going to finish this and then we'll take a break and we'll come back. Sound good? All right. Contingencies included in the purchase and sale. In the GAR contract form, due diligence is the only contingency that is negotiated between the buyer and the seller in just the purchase and sale agreement in and of itself. Any other contingencies like financing contingency, appraisal contingency, sale release of any other contingency must be addressed in a separate document, in a separate exhibit in GAR. Okay? In the RE forms package, in the purchase and sale, in and of itself, there are 3 contingencies. The buyer's right to terminate, which is the exact same thing as due diligence, and the financing contingency, and the appraisal contingency. Those are all 3 addressed in the purchase and sale of the RE forms. So you wouldn't need any additional exhibits. The only additional exhibit you would need in the RE is if the buyer is getting an FHA insured loan or a VA insured loan, then you will need additional exhibits even in the RE forms. Easy way to think of that is FHA and VA are what type of agencies? Government. So what do you think of when you think of the government? Wait, don't answer that right now. That's a loaded question right now. But yes, you think of more paperwork, right? So anytime you are working with a buyer who's getting a VA insured loan, FHA insured loan, I don't care what contract package you're working with, you're going to need a separate document, additional paperwork, okay? Now, I will tell you that the RE forms does have a separate, turn in your RE forms package, package number 3, turn to page 17 and 19.
And I'm sorry, which loans again did you say?
FHA and VA.
FHA and VA.
Yes.
And on both forms, they require separate.
So you're going to need a separate exhibit regardless of which package you go binding on. All right. The RE forms does have a separate page that says financing contingency exhibit, and the next page it has a separate document that's an appraisal contingency exhibit. If you go binding solely on the RE forms, you do not need these separate documents. All the verbiage in these pages are contained in a combination of the contract and the standard terms. The only reason they even came up with this is if you're doing what I like to call the switcheroo, just like this example we're talking about. Let's say you're an agent and you don't have access to the GAR forms. So you write an offer on behalf of your buyer on the RE forms, and it's a conventional loan. You don't need anything separate. Everything is contained in the purchase and sale. Those contingencies are already, with the number of days and everything, is already in the purchase and sale.
Even for an FHA loan,
No, FHA and VA, you're going to need this separate exhibit, but in this example, it's a conventional loan. Okay? So, conventional loan, you're representing a buyer, you write the offer on the RE form. That's all you have access to are the RE forms. You get a counter offer rewritten on the entire GAR purchase and sale. The listing agent has not taken this class and doesn't understand that those financing and appraisal contingencies are contained in the purchase and sale and isn't paying attention. So all they counter back with is everything rewritten on the purchase and sale. Well, the purchase and sale in GAR does not have a financing contingency or an appraisal contingency. The rest of the terms of the purchase and sale are fine, but you need to protect your buyer with the financing and appraisal contingency. That's the only reason you as an agent are going to pull out these standalone forms. Make sense? On the switcheroo if you don't have access to GAR. All right? All right. Let's take a break and we will come back and knock out the rest. I have 1 o'clock. Woo! Let's come back at 1:15 and we'll finish up in 45 minutes and I'll talk faster. Chris, should I turn this off or leave it on?
Go ahead and leave it on.
Okay.
Hey, so with that RE form and the financing contingency and stuff, I thought you had to tell people how you're gonna buy a place, and if you don't include